monitored and controlled through the processes of the court.
Lord, can I?
We are not at any point of time saying that there is expediency and there is a requirement for legislative process to be completed within a time.
Lord,
But to fix it on a time schedule, the biggest risk court takes more than anybody.
Lord, I'll put, we are concerned with Article 200. Lordship will just visualize Article 200. We'll forget education, taxation, land acquisition. Let's take Article 200. Lord, the draftsman has made it as soon as possible. He has given a clear hint that as soon as possible. Now, I ask myself the question, if as soon as possible is creating problems in a working situation, where, as just Mr. Venugopal said, in 23 states it is done immediately, in 5 states it is taking 6 months, 7 months, 2 years, 3 years. I am asking the question, my lord, what is the power of the court to say as soon as possible shall mean an outer limit of 6 months? What is wrong with that? And what the court has not said, you must do it within 6 months. That's not what division bench says. Division bench says, if you don't do within 6 months, you can come to court for redress. That's what the division bench says, the 2-judge bench. But I am putting a proposition for Lordship's kind consideration. Is the court's power is not fettered if they feel that as soon as possible is vague, is leading to. Sorry, Murad.
We are only answering the question. So
No, I'm not. So I'm just saying what in the light of what Justice Narasimha said, in a constitution should be what can be done in a statute. Can it be done in the constitution? My submission is, if as soon as possible was not there, then it was a completely different cup of tea. But where Parliament has said as soon as may be possible, they've used it in 62, election of a president, 68, election of vice president. They've used it in Schedule 6. So whenever they said as soon as possible, suppose during the working of the constitution you realize
Respect to such an expression, the courts will still have jurisdiction.
yes,
You can't have a constitutional logjam. And
Yes.
just because those words are there, it doesn't mean that we have a problem.
no,
It depends on.
No, I'm saying that I'm putting it this way, Manoj. There is a law, which is the statute. There is an interpretation put by your lordship. The law is X, your lordship's interpretation is Y. X plus Y becomes the Article 141 law. Ultimately, the statute says something. Your lordships interpret that particular statute. Now, your lordship's interpretation on that particular provision as to what may be reasonable, what is the outer time limit, read both together becomes the law under Article 141. I am saying that this need not be a Article 142 power at all. Suppose your lordship finds as soon as possible. I am asking myself the question, however complicated the law may be, do you require 3 months to give a message?
Even if as soon as possible was not there, still the governor would be expected to act in a particular time,
Yes.
in a reasonable time.
Yes.
Correct.
So,
Even if as soon as possible was not there, as soon as possible says, all right, expediency is there. Without that, those words phrase also, there would be some expectation within a reasonable time and
Yes.
normal behavior
yes.
from a governor to,
Yes.
when a bill has come to him, he has to do something or the other.
I'm building upon what your lordship is saying. I'm saying that when the constitution makers made it 6 weeks, made it to as soon as possible, they always contemplated a definite timeline. It can't be kept endlessly pending. And why? Because I've been elected on a particular mandate. So tomorrow, Tamil Nadu government may want to impose prohibition. The governor may say, no, this is not a good law. I'm not going to implement it. You can't do that. So my submission
Can't
is,
test the validity of the law. The governor cannot test the validity
Yes.
of the bill, yes.
so I'm
To
only
the
saying,
correctness of that bill.
yes, I'm only putting as a proposition of law, if as soon as possible, the highest court of the land interprets say, as soon as possible will mean a period of 3 months, a period of 6 months. I'm not saying there's anything unconstitutional about
It
it.
would be an urgency, it would require 24 hours for the governor to act.
Maybe, it may be. Some disaster is there, tsunami takes
Correct.
some.
Whatever.
Or as Mr. Venugopal put it, there is a money bill and there's an appropriation bill under Article 114. Now, money bill is under 111, appropriation bill is 114. Can you stop appropriation bill, pass the money bill and don't do the appropriation? Well, ultimately,
There could be situations,
Lord, all these are components of a well-oiled engine, which is the government. Everything has to work together. You can't have one particular component not working in sync or harmony with the others. Otherwise, everything will break down. And what the constitution contemplates is all of them work to the common goal of a particular government. A government has been elected. It has got the mandate of the people. The governor has to respect that mandate. That's all I'm saying. I'm answering my lord's question that can we impose a time limit in constitution? My answer is yes. Lordships can. If lordships can lead basic structure into the constitution, lordship has led substantive due process into Article 21. Why can't the lordship fix a time limit? If the lordships can go so far as to bring in substantive due process in 21, overrule A.K. Gopalan, why not? Then lordship first said 14, 19, 21 are separate. Then my lord said no, all should be read together.
Trinity
These are
of-
all
Trinity of
Trinity,
19 and
yes,
21.
bank nationalization case.
Maneka Gandhi also.
Maneka Gandhi also. Yes. So I'm only putting to lordship. I'm saying there's nothing wrong in the presidential reference to ask, can the court do so? Answer, the court can do so if it's necessary. And I'm asking, how many times has the court in the last 75 years, how many times has the court put timelines? Hardly 2-3 cases. In rarest of rare cases has happened. And then why should we complain about it? We should welcome it, yes. Now throughout the country, all governors must give assent within 3 months. If they don't do, the litigant can go to the court. Is there anything wrong with that? Will heavens fall? Will entire administration go into chaos? Will there be a constitutional crisis? My answer is no, my lord. There is no reason to feel upset about it. You can only say on a principle, no, it is not that I will not be bound by any time limit. The constitution doesn't say time limit, I will not be bound by it. That, in my humble submission, cannot be an argument. I'll go to the next point, my lord. Then my submission is, I've taken the plea of constitutional trust, which has not been taken.
The submission.
Yes, Roman 3. Lord, in 2.3, I'll read. Lord, over the weekend, there's an article by Professor Lon Fuller, where he talks of congruence. He talks of congruence. Congruence is the making of the law and the implementation of the law. If the law is implemented the way it was intended, it leads to congruence. If it is not done so, it leads to dissonance. So I'm just putting 2.3, Lordship may just see my proposition. Setting a time limit is essential for constitutional congruence. It makes explicit what was always implicit. What a lordship said, reasonable time. Give it okay, 3 months, 6 months.
If it doesn't act, then come to court.
No, or I'm going to come to constitutional bypass. Go to 368. Say reasonable, delete as soon as possible. Then, Lord, Doctrine of Constitutional Trust. Lord, in Manoj Narula, I'll just read one passage from CIRY, 2014. It's at volume 45, V45, page 17984. Very nice passage from Mr. CIRY, late CIRY. Here he talks, page 17984. It starts at 17984 under the subheading Constitutional Trust. 17984. Basically, what they say is there is a belief that the highest constitutional functionaries will discharge their constitutional trust. 17984.
Starts from 17934. You are reading at page?
17984. And if your lordship permits me, my lord, I'll just read to 17983, para 82, which is the next point I made. I read para 82, my lord.
Para 82.
Para 82. May I read, my lord, para 82? Yes. In a democracy, citizens legitimately expect that the government of the day would treat public interest as the primary one and any other interest secondary. The maxim salus populi suprema lex, not only to be kept in view, but also to be revered. The faith of people is embedded in the idea of good governance, which means reverence for citizen rights, respect for fundamental rights and statutory rights. This is most important, deference for unwritten constitutional values. Deference for unwritten constitutional values. And my submission is one value is.
Exercise is constitutional power.
Yes.
reasonably is inherent in the power itself.
Correct. Correct. Your Lordship is right.
Need not be superimposed.
No.
So if the power exists, one has to read. within
Yes,
the power-
like a Lordship said in Article
within the
200.
power
Yes.
that it must be exercised. in
It's a power given in trust.
reasonable time. and-
Yes, yes, Lordship is right. So I'm just relying on the passage deference for constitutional values. Constitutional values means once a government is elected and it passes a law, it passes a fisheries amendment bill, you have to pass it. That's the end of the matter. Now, please come to para 83, constitutional trust. My Lord, the Honorable Supreme Court reproduces important passages from Ambedkar, Samshay Singh. I'll skip all that. What is interesting is what the late jurist Mr. Sirwai wrote in para 88. I'll just read the extracted portion. While discussing about the successful working of the cabinet form of government, H.M. Sirwai, the eminent author of Constitutional Law, observed. Now I'll read this, my Lord. The Constitution does not guarantee that power would be wisely exercised by the executive. But as long as the political atmosphere remains what it is, the Constitution cannot be worked as it was intended to be worked. It has been said that the Constitution confers power, but it does not guarantee that the power would be wisely exercised. It can be said equally that the Constitution confers power, but gives no guarantee that it will be worked by men of high character, capacity, and integrity. If the Constitution is to be successfully worked, an attempt must be made to improve the political atmosphere and to lay down and enforce standards of conduct required for a successful working of our Constitution. So to lay down standards of conduct or lay down timelines for the effective working of our Constitution is the discharge of constitutional trust. This passage, Sirwai, is extremely important, my humble submission. Now I go to the next passage. Please come to 3.4. I have extracted from Sivanandam. This is High Court of Kerala. It was in a different context. But I'm relying on all these things to say that these timelines or these things which I've mentioned are nothing wrong, nothing unconstitutional, nothing warranting a presidential reference as such. In C.T. Sivanandam was High Court of Kerala. I'm reading 3.4, my lord. It was held in paras 44 and 45. In a constitutional system rooted in the rule of law, the discretion available with public authorities is confined within clearly defined limits. The primary principle undermining the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle or rule is unpredictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing the expectations of citizens from public authorities. The principles of good administration require that decisions of public authorities must withstand the test of consistency, transparency, and predictability to avoid being arbitrary. So now, my lord, what is important is the consistency and predictability in decision making. As somebody said, not taking a decision is also a decision. So the point is, once the bill is presented, if the Supreme Court has enforced a particular standard, I think it's completely in consonance with our constitutional values and our constitutional provisions to make the cabinet system of government work. Otherwise, the cabinet system fails. You have an elected government, they form a cabinet, but they can't pass a law. It's a logjam, it's a constitutional deadlock. Now, the very important point I want to make is this judgment of natural resources, in my humble submission, is, with all humility, my lord, does not lay down the correct law is my submission. Natural resources. That was your lordship saw in the aftermath of the 2G case. It has already been cited. Where I feel the judgment is incorrect and it is contrary to Indri Kerala Education Bill, is that it says that under Article 143, if a lordship is exercising advisory jurisdiction under 143.1, your lordships can evaluate and clarify another judgment, an earlier judgment. That's a very, very serious proposition to ponder. In an advisory jurisdiction under 143, can this court evaluate and clarify what is the law? I am saying that the judgment is incorrect It is per incurium because it is contrary to what Chief Justice Das said in Kerala Education following Lord Spence. And it is obiter because in that case, the Attorney General said we are accepting the 2G judgment. We are not questioning the correctness of the 2G judgment. The Lordship sees the questions. In fact, what we have done is kindly come to, where is the chart? My lord, my friends have prepared a chart of all the 15 references which have taken place with paragraph numbers, what is held, etc. Please see that they have done a very marvelous job. 1126,
Yes.
page 1126. Volume?
Same,
Same volume.
2.8.
Same volume. Oh, yeah, after my, sorry. 112. This is after my written submission, sorry. Now, my lord, kindly see, from INRI Delhi Law's case, they have gone into what is the issue, what were the questions referred, what was answered. I am concerned with INRI Natural Resources, which comes at page. Well, there are totally 15 references, and each and every reference has been elaborately discussed. 141147. The Lordship knows, all of us know this 2G, all the licenses were cancelled. And the Supreme Court directed that the government should give spectrum not on this first come, first serve basis, but on auction basis. That was the. Now kindly come to the question that was said, referred to the larger bench, 5-judge bench under Article 143. Now please come to question 1, 2, 3, 4, were answered. Basically, they say auctions are not the only permissible method. There can be exceptions to auction. Now, if your Lordship comes to the last column, last square in page 1147, Lordship has got that?
Yes.
In the answers to so, the following questions. Lord, in this case, reference, the 2G judgment was annexed. And the correctness of that judgment was sought to be questioned. The judgment was an annexure. Now kindly see at the last row.
In the light of the statement.
Yes, whether the judgment is required to be given retrospective so as to unsettle license issued by so and so, whether allocation and so and so, all the questions were asked. In the light of the statement,
1147.
1147 bottom.
1147 bottom. In the light of the statement
Yes,
of the Attorney General that the government is not questioning the correctness of the 2G case, the court declined to answer. And all the remaining questions were relating to the correctness of the 2G judgment and the effect of that judgment. And throughout, right up to page 1149,
The same answer.
same answer. So, having answered that, they need not have gone into the scope of 143.1. Completely unnecessary. Now, kindly come to what they have answered. They discuss Kaveri 1, Kaveri 2. Please come to para 65. At 1151. We are therefore, sorry. Yes, this is on the scope of 143.1. We are therefore of the view that as long as the decision with respect to allocation of spectrum licenses is untouched, this court is within its jurisdiction to evaluate and clarify the ratio of the judgment in the 2G case. For the purpose of this stage of argumentation, it needs little emphasis that we have the jurisdiction to clarify the judgment in the 2G case, irrespective of whether we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to that has been enunciated in 2G case as a proposition of law cannot strike at the root of the maintaining the reference. Now, what they say, this proposition, how they implement it is this. What they say is, we will declare a law contrary to what 2G said. We will declare the law, but we will not affect the decree. Kindly see, that's a very dangerous precedent. And that is discussed in para 60, yes. Yes. Para 61. From the aforesaid, he says it can't affect the equity. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modification may be stated as one of the mode or method of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one can't be oblivious to the fact of limited judicial review in the second judge's case, which is otherwise quite restricted, etc. My lord, my submission is, please come to para at page 1150. They say, kindly come to this last but one paragraph, the second limitation. Lordship has got that at page 1150, because this is seriously problematic, my lord. And subject to what the Lordship says, this cannot be the jurisdiction under 143. Kindly come to page 1150. The last but one paragraph, Lordship will say underline starts with in fact. Lordship has got it. In fact. In fact.
Overruling.
Yes, in fact, the overruling of a principle of law is not an outcome of an appellate jurisdiction, but a consequence of its inherent power. This inherent power can be exercised as long as a previous decree vis-a-vis inter partes is not affected. It is an attempt to overturn the decision of a previous case that is problematic, which is why the court observes that under Constitution, such appellate jurisdiction does not vest in this court, nor can it be vested by the President under Article 143. Then they say that we will make the point of law, but it won't affect the decree between the inter partes. My submission for Lordship's kind consideration is this. The jurisdiction under 143 is only to answer a question of fact or law referred to by the Honorable President to this court. My submission is the jurisdiction under 143 is not to clarify or evaluate. When you say evaluate, what do you mean evaluate? You're considering the correctness of an earlier judgment. With greatest humility, my lord, I will say the jurisdiction under 143 does not extend to this court evaluating or examining the correctness of a view. Just see what the consequence is. Indira Sawhney says 50% is the limit. Article 14 doesn't say 50%, 15 doesn't say 50%, 16 doesn't say 50%. You have fixed a percentage. They also go further and say 50% applies to promotion also. Now, can you have a reference to a bench of 11 judges to say, to evaluate and decide the correctness of Indira Sawhney? Answer is no. In case that judgment is wrong, then the remedy is Article 368. If that judgment has interpreted a ordinary statute, amend that statute, remove the basis. If it has interpreted the Constitution, then only remedy is 368. My submission is Article 143 is not a constitutional method to bypass Article 368. It will be a dangerous situation if the court says there is one judgment of 3 judges. It is, let's say, problematic. Use yours. So let us have a reference of 5 judges and we'll evaluate the correctness of that judgment. With great respect, my lord, that cannot be done under 143. If you go under 368, amend the law, delete as soon as possible, or say the governor will not be bound by any time limit. So I am only submitting the observations of this court, and I'll tell your lordship why. Even in the federal court, in fact, Mr. C, I was discussing with Mr. Subramanian at lunchtime. Mr. CRY, I got a second edition. INRI estate duty. What happened was very interesting. There was a case called INRI levy of estate duty. AR 44 Federal Code 73. The federal court gave an advisory opinion. Advisory opinion under the Government of India Act. The High Court started following that advisory opinion as binding. The federal court says the High Court has fallen into an error in treating the advisory opinion as a binding principle of law. That comes in INRI Kerala Education Bill, and Kerala Education Bill says, yes, that is correct. And they cite Kerala Education, but let us not forget, in Kerala Education, they comment on the correctness of a federal court judgment. Supreme Court is supreme. Federal Court was not supreme. So Federal Court was subject to Privy Council. So in Kerala education, Justice Das comments upon a observation of a Federal Court judgment. Nothing wrong with that. But my humble submission is, since your Lordship has got the occasion to see this reference, a presidential reference, in this case, we are basically testing the correctness of a view taken by a bench. Though we don't mention it. We are saying, can you impose timelines and so on and so forth. I am saying that natural resources is a wrong law to say that you can evaluate and decide the correctness of another judgment in that court. So indirectly, you're making an intra-court appeal when there is none. It can't be done under 143. Suppose the 2G judgment, suppose there's a judgment of 2G by 2 judges. It comes before another bench of 2 judges. Following the Dawoodi Bohra pattern, they can say we doubt the correctness of it. Let it go to 3, let it go to 5. Of course, that doesn't bind my Lord the Chief Justice. He can constitute any bench he chooses. But I'm saying that if it's a 3-judge bench, then answer is not to create a reference and evaluate the 3-judge bench. Either it goes the Dawoodi Bohra route or it goes by the constitutional amendment. That's my humble submission. Yes. Now, coming back to my submissions. I was at page. Yes. Please come to 4 point.
Absolutely.
But at 11:24, I'll just read that paragraph and just to reiterate what I've said. One, two, three, last 2 sentences. May I continue? 1, 2, 3, last 2 paragraphs, last 2 sentences, and I'll go on. I have only one more point on constitutional conventions. Constitutional trust. Sorry, I have natural resources, yes. 4.1. In natural resources zones held under Article 143(1), the court has a jurisdiction to evaluate and clarify the ratio decedent in the judgment 2G case. It is submitted that this observation is both per incuriam and obiter dicta because the Attorney General had repeatedly stated that the executive accepted the judgment in the 2G case. Further, the power to give an advisory opinion does not include the power to evaluate and clarify a judgment of bench of 2, 3, or even 5 judges. My submission is 143 is to answer a question of fact and question of law sent by the president. That's all. And that question of law cannot be a question of law that seeks to evaluate another judgment. That's my humble submission. Now, kindly see the next submission. I don't know if anybody has dealt with it. If so, I'll skip it. Number 1, under 143(1). What can be answered by this question is questions of fact and questions of law. Questions of fact and questions of law, which the president has a doubt. And the Honorable President wants the opinion of the president. Lordship sees all the 15 references which are given. Barring natural resources where the 2G was there but given up, nobody has evaluated or clarified whether it is INRI sea customs, what's the scope of Article 285, or in the Delhi laws, what's the scope of delegated legislation. All these are questions of law which the president had a doubt and the president makes a reference. My submission at 4.2 is this, Lord. Now, question of law is there in CPC, substantial question of law. In every tax statute, there is a question of law. High Court only on questions of law. And I was surprised to note, my Lord, that under section 100 before 76, there was no reference to question of law. That was only in section 109. But in 100, they introduced substantial questions of law. Meenakshi Mills, Justice Venkatramayya has discussed at elaborate length what is question of fact, what is question of law. I am not on that. I am on the point that if the Supreme Court has delivered a judgment on a statutory provision or a constitutional provision, then that is a law declared under Article 141. My lord will see the presidential reference in this case. The questions referred are issues framed by the two-judge bench in this very case. For example, the first question which is there, what are the constitutional options? Issue number 1. If your lordship takes question number 2, it's issue number 4. So I'm putting a proposition of law. If the Honorable Supreme Court, because it's a what they call polyvocal court, you can have bench of 2 judges, 3 judges, 5, but whatever it may be, it is Article 141. So my submission is, if a particular bench has framed an issue, answered the issue as a question of law, then on that point 143(1) will not arise, because there is no other, because the president has to only follow that judgment, that's all. Or parliament is to amend the constitution or amend the statute, whatever it may be. So I'm putting forth the proposition that 143, the lordship sees that section, just 1 minute. Yes.
The president.
My friend puts it very, Sadan put it better. Sorry. My friend Mr. Farasar put it quite well. He said, once the question of law is answered, it's no longer a question, it is the law. Then there is no question of law. It says, if any time it appears to the question that a question of law or fact has arisen or is likely to arise, if such a nature. If a question of law has arisen and it has been answered by the court, then 143(1) will not. Sorry, man.
Yes.
Yes. I'll just go back to my submissions. No, my lord, because since your lordship is now laying down the law for all future times to come, if there is a declaration of law by the Supreme Court under Article 141, that should not be a ground for a reference, is my humble submission.
We did not come to argue as a preliminary objection that the reference is not maintainable. We have been hearing on all the 13 questions.
No, I was told your lordship said did not go to maintainability. So I'm not saying it's not maintainable.
No, we have what on the maintainability?
Nobody argued, Manoj, on that side, this side.
All
It
right.
was argued. I didn't want to interrupt, but
Yes.
it was raised. Okay.
No, I'm only saying that the reference is there. What I'm submitting is, if the question.
You are
is
not on maintainability.
I'm saying that if one question referred to the honorable court has been already answered in a judgment, it can no longer be a question of law. That's my submission. So suppose there are 12 questions, hypothetically, and 6 questions have been answered in a judgment. Those cannot be the subject matter of 143(1) is my question. Because there could be some questions which are open. That's why I'm not getting into, but I don't want to be hyper technical. Today we have to answer a very important issue on reference jurisdiction. And whatever law lordship lays on is going to be there for the next 15, 20 years. That's what I'm submitting. So my submission is, because what the president refers are questions. And those of us who have been, again, going back to tax, old 256 lordship, no, when lordship were juniors at that time, there used to be a reference jurisdiction. High Court did not have appellate jurisdiction. It will go to the High Court for the reference as an opinion. Based on the opinion of the High Court, assessment order is then passed. And the Honorable Supreme Court has said in Lala Bansidhar's case, if there is a reference, then there is no question of any merger and all that. The advice is given by the reference is answered by the High Court and the assessment is complete. And even though the matter goes to this High Court for a reference, the tribunal continues to be seized of the matter. It's not that the record has gone to the Superior Court like a first appeal. So High Court answers the question of law.
Then after a final order is passed.
And then assessment order is passed in terms of the assessment, unless it's modified by the Supreme Court. So my humble submission is, what is the meaning of 143, questions of fact and questions of law? If it's a question of law answered, then that can't be the subject matter of 143(1). Now kindly see, my submission is, paragraph 4.2, once the president will require an opinion only on a question of law on which there is a doubt. 4.2, just 2 minutes. Once a judgment is delivered, the only way its basis can be challenged is by a constitutional amendment, Article 368. That is slightly, if the judgment is on a constitutional article. That's why I said, Indira Sani, the Supreme Court said 50% is there. They also said 50% will be for promotion also. What did Parliament do? 77th Amendment. 16(4)(a). Promotion will not be, 50% won't apply to promotion.
Indira Sawhney said that the reservation will not apply to promotion.
50% limit applies to promotion also.
Indira Sawhney said that
No, not promotion. It's not apply to promotion. So it's apply to this thing.
it
Then-
applies only to appointment and not for promotion, and therefore
Yes,
the
16(4)(a)
first
came.
amendment.
16(4)(a). 16(4)(a) amendment came. Similarly, carry forward rule. They said the reservation will not take into account that carry forward rule. That also was, so I'm only submitting, you could not evaluate and correct
It's for the parliament to correct accordingly.
for the by constitutional amendment.
It's by constitution amendment.
Yes, yes,
If they want to overcome the judgment of the revision bench, they can't do it by way of reference.
because it's a
The
360.
only way available to them is by way of the constitution amendment.
Because they've interpreted the constitution. That's why the Maratha reservation is we succeeded on 2 rounds, because it can't be done by a Maharashtra legislative act. That 50% limit can't be crossed by a Maharashtra law. Now, again, my friend argued on this, adding to the list of scheduled castes.
That is again going on before Bombay.
Which one?
Bombay High Court, Maratha reservation.
I concluded my arguments, Varun. No, again, 4th round is coming after the recent. Both of us were there, both of us were there in Bombay and then Supreme Court.
Full bench.
Then, my lord, it came to Jayashree Lakshman Patil here. And where, my lord, the bench held that under 342, the state can't amend the list. Again, the constitutional amendment.
What is your answer to 145(3),
Huh,
which requires that any question with regard to interpretation of the constitution
yes.
has to be heard minimum by 5 number of judges?
My submission is, please see the provisor to that. Please see the provisor to 145. Yes.
Yes, provided that.
His lordship will, my friend says, please read 145(1). Yes, that says yes. Now kindly come to 145(2). Subject to the provisions, the articles may fix a minimum number of judges who was to sit for any so and so, so and so. 3, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of the constitution, or for purpose of referring any reference under 143 shall be 5. Now please see the proviso. Provided that where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the courts of hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion of law constituted as required by this clause for the purpose of deciding any case involving such cases, and shall on the receipt of the opinion dispose of the appeal and so and so.
So therefore, then the court was required to refer that question to.
No, if the court is satisfied, my submission is first twofold. If it's a writ petition under Article 32, and there's a bench of 2 judges before whom the challenge comes, there are any number of cases where this honorable court in sitting in 2 and 3 have struck down a particular law under article constitutional provision. They've interpreted the constitutional provisions. I can give any number of cases it has done so. So what I'm saying is under 145, the minimum judges who are to sit for the purpose of deciding any case.
Struck down the constitutional provisions.
Yes. Or it has upheld the provision. They've heard constitutional issues. The entire issue of service tax, All India practitioners case, it was heard by 2 judges. I'll give so many other examples. The cooperative society was struck down by 2 judges. Remember, this 145(3) has come at a time when the Supreme Court used to hear all matters en banc, 5. Now, over a period of time,
One
it's
of
not.
the cases, request was made that refer it to the larger bench.
Which one?
Here, the learned AG did make a request.
But if it is not, the way I referred to the proviso was, the court hearing the appeal, let's say the appeal can be an Article 32 petition. Suppose a reason is made that this matter should be referred to 5 judges. And the court says, no, not necessary to refer to 5 judges. Jayashree Lakshman Patil, 3 judges, right?
5 judges.
No, no,
5 judges.
which are heard by, Nageshwar Rao, Hemant Gupta and 3.
But to
I think your lordship also know.
It's 5.
Hemant Gupta and Ravindra.
It's 5 judges.
Ravindra.
Why judges?
It is
One
it
judgment.
appeared through virtual
The
hearing.
next
during
round,
COVID.
the next round came. What we argued was this was thought to be referred. We argued that since the matter is already concluded, though it involves interpretation, there is nothing further to answer and so on. So I'll give any number of cases where 2 judges benches, 3 judges benches have heard matters of constitutional interpretation. And in any case,
Just one-
at best, it can be an illegality or fatality.
Ashok Kumar Thakur, which is 2007, 6 SEC page 1, if I'm not wrong. Before it was
Last
referred,
number.
right, 2 judges to 5 judges. The 2 judges stayed section 6 of the reservations, Central Reservations Act. By 2 judges.
And I would submit, Murad, to answer 145.3, my proposition is this. Sorry. I'll put for Lordship's kind consideration. 145.3, over the years, 145.3 is not taken as a necessary mandate. Not constituting a 5-judge bench is not an illegality or irregularity.
When a specific request is made to a bench,
Hmm.
that these matter requires interpretation of constitutional provisions.
Hmm.
Anyway, we are not sitting in an appeal court.
Yes. Understand. They go for a review. Go for a review. You review curative, whatever it may be. No, I'm only saying that you can't take up at now in 2025 and say a bench of 2 judges decide a constitutional provision. They have not struck down any particular provision. They've only said, please see the judgment below. What have they said? They've interpreted, Lordship, see the particular judgment also. Have they struck down any particular provision? No. They have said it should be done in 3 months. If it's not done in 3 months, you can approach the court. And kindly see, and deciding But one more point I'll raise, since we're on a principle law, not put this particular judgment. Now the question is, suppose tomorrow I file a writ petition challenging a particular provision, or from the Madras High Court or High Court it comes on appeal. It involves a question of law. I raise an objection saying it should be heard by a bench of 5 judges. A bench of 5 judges. I raise an objection. Suppose the court feels that yes, it requires interpretation, yes. Now in this case, it should be a case involving a substantial question of law as to interpretation of the Constitution. Suppose the court is going to rely on a series of precedents and decide, it may feel it's not necessary to go to 5 judges. I've got enough case law to take a decision on that particular point of time. I'm only saying that let's not create a situation, otherwise we will not be able to decide many matters.
Yes.
Everything will be for 5 judges. But I don't want to go on this fear psychosis. I'm only submitting that there is a practice of this court of 2 judges and 3 judges deciding cases of constitutional law. Here it talks of involving a substantial question of law as to the interpretation of this constitution. My humble submission is, this court has only said as soon as possible is equal to 3 months. That's all. Nothing. It has not struck down some great constitutional provision by 2 judges. No. I can understand like Indira Sani decides multiple questions by bench of 2 judges. Yes. That's my submission. Yes. How do you deal with objection of validity? Yeah. Yes. And one more thing, Manoj. In para 239 of the judgment, His Lordship says that our interpretation is not to be taken as an interpretation of 200, but to be considered as guidelines to attract judicial review. I'll read that passage, para 239 of the 2-judge bench. Any time limit in the exercise of powers in terms of Article 200 of the Constitution should not be construed as timelines laid within the edifice of the provision, but should be understood as timelines that serve as a lodestar for the purpose of exercise of judicial review by the courts, a benchmark tool to aid and enable the courts to ascertain if any action or malfeasance has occasioned the exercise of such powers. So, well, I'll just go to the other part. Hmm? But then your lordship will have to frame a question that if a question of substantial import of constitutional interpretation comes, substantial question of law, constitutional, should it be heard by a bench of 5 judges? If that is the answer, then we are going to have a question where there will be a threshold limit first deciding. Is there a substantial question of law? If the answer is yes, it has to necessarily go to 5 judges. If your lordship feels that should be there, so be it, my lord. Now kindly come to, but I'm only submitting that could lead to serious problems of arrears in the long run. Now kindly come to 4.3. A chart is annexed which sets out the details of 15 references under Article 143(1). There has never been a reference to take up a question of law which has already been answered. Chart containing details of all 15 references is marked as Annexure 1. Now I come to my final submission on constitutional conventions. Now, my lord, the Constitution doesn't provide for everything. Practice adopted by constitutional functionaries, be it the judiciary, the legislature, the governor, the president, that they set out conventions which are to be followed. Our Supreme Court has said a convention taken over time is as good as constitutional law. Constitutional convention also amount to constitutional law. Now I'm asking myself the question. Is there a constitutional convention of approving a bill at the earliest opportunity? My submission is Article 111 and Article 200 are mirror images, barring minor differences. Both talk of assent to bills. They don't talk of scrutiny of bills, examination.
You have already argued that.
No, I'm saying constitutional convention. So I'm just quoting a passage from May, and I'm going to say that there's a convention. I'll put this properly, my lord, the Chief Justice will ask the question. I'm saying that if there is a constitutional convention of the president giving assent to the bills, and very, very few examples are there where it has been withheld for some small period of time. If there is a convention under Article 111 to approve the bill at the earliest, as soon as possible, which is also a term used there, the same convention must apply to Article 200 also. Because what the governor is to the state, the president is to the country. In a federal setup, the governor performs the same role as my friend put it, I'll show his passage later. In a Westminster form of government, in a presidential form of government, the president is also the head of state. But in a Westminster form of government, there's an elected government and there is a head of state, a symbolic head of state.
Titular head.
A titular head or a titular head, like the queen or the monarch or the president or the governor. He is not just for a mere symbol, because governments will come and go, but the president is there, the governor is there. He symbolizes the state. He is the head of the executive. He symbolizes the state. He becomes the supreme commander. All those things come which have followed the British pattern. Now I'm going to come to two passages from Erskine May's 1924 edition. It is not there now because now they have passed a Royal Assent Act in 1967. But yes, but what is the convention? Please come to para. Very interesting passage from Erskine May. At para 1.5, just two more passages and I am done. Page 1120. The constitutional provision, Lordship has got it. All your Lordship, page 1120. The extract from May is very interesting. The constitutional provision to grant assent has been borrowed from the Westminster model. The royal assent is to only complement and perfect the law. The following passages in Erskine May's Treatise of Law, Privileges, Proceeding, Usage in 1924 are important. Page 430. But I've extracted that page also. When bills, either public or private, have been finally agreed to by both houses, they only await royal assent to give them, as Lord Hale says, the complement and perfection of a law, and from that sanction they cannot be legally withheld. Now 433 is even more important. The form of words used to express denial of royal assent would be le roi s'assuera. Assuera means the king withholds, the king is going to consider. That's the French term used before 1967. the necessity of refusing the royal assent is removed. Now, this is very important. Bro. The necessity of refusing the royal assent is removed by the strict observance of the constitutional provision that the crown has no will but that of its ministers. Aid and advice. The crown has no will but that of its ministers, who only continue to serve in that capacity so long as they retain confidence of power. This power was last exercised in 1707 when Queen Anne refused assent to a bill for settling the militia in Scotland. Now, Manoj, coming back to my page on constitutional conventions, I just read that passage and I've concluded. Manoj. Para 5.1. Just read this. Just 5 minutes more. Manoj. The grant of assent by the president is set out in Article 111. Barring very rare exceptions, the president has followed the UK pattern of not withholding assent. This practice of president assent not being withheld must be followed by governors. There cannot be one constitutional convention for the president and another for governor when the ambit and scope of Article 111 and 200 are the same. Conventions play an important role in understanding the real purpose and function of a constitutional provision. I've given the footnote, but I won't trouble your lordship. I've given the para number also. British conventions assume special significance in understanding the parliamentary system of India, since it's akin to the parliamentary system of England. In the second judge's case, it was held that the written constitution cannot provide for every eventuality, and hence the gaps present in the constitutional provisions are to be filled by constitutional conventions. This honorable court also held that there is no distinction between an established constitutional convention and constitutional law, as they are both binding in their respective fields in which they operate. When it is established that constitutional convention exists, it would be enforced in a manner similar to constitutional law. Now, UNR Rao's case is important. Article 111 and 200 place a president and governor in the same position as the king/monarch of England. In UNR Rao versus Indira Gandhi, it was held that Article 75(3) has to be interpreted, take the judgment, with the conventions which prevailed at the time the constitution was framed. Please see that judgment, Lord.
That was already been read to us.
UNR Rao para 3? All right. So I am submitting that if 75(3), if the convention of 111 is not to withhold assent, please apply the same convention to 200. Because what convention applies to one provision must also apply to a pari materia provision of the constitution. That's all. Now, Lord, from Mr. Shadan's two passages, yes, he wanted to two passages.
Your charge was 45 minutes, but you already taken 80 minutes.
Sorry, but he has one interesting passage he mentioned about one book. I'll just leave it again. Just take 2 lines I can show because he wanted to. I'll read that one. What just permit me. Please come to 1155 with the same page and I'll stop with that. Yes. Please come to page 1156.
He's not shameless.
A nominal head of state, Rashmi's got it? A nominal head of state, unlike the head of government, has only 3 powers. Page 1156, para 5. Then extract is there. Please come to para 1157. And the bold portion, there's 3 lines I'll read. Lordship's got that?
Yes.
To state the matter shortly, by Walter Bajeho. To state the matter shortly, this is the role of a sovereign. The sovereign has under a constitutional monarchy such as ours, 3 rights: the right to be consulted, the right to encourage, the right to warn. And a king of great sense and sagacity would want no other. He would find that his having no others would enable him to use with singular effect. He would say to his minister, the responsibility of these measures is upon you. Whatever you think best must be done. Whatever you think best shall have my full and effectual support. But you'll observe that for this reason and that reason you propose to do is bad. And for this reason and that reason you do not propose is better. I do not oppose. It is not my duty to oppose, but I observe that I warn. So the role is the right to consult, right to be consulted, the right to encourage, the right to warn. Therefore, my humble submission is, my lord, as far as this reference is concerned, all these questions have been answered, and the points that have been raised Since they're already questions of law answered, these questions need not be answered under Article 1, should not be answered under Article 143(1). Particularly that in the natural resources is the most problematic judgment of saying under 143, a referral bench, an advisory bench can evaluate and clarify a law would be very dangerous, deeply obliged.
Take about 10 minutes.
Only one council for one state.
I'm appearing for internet also.
No, no, we have.
10 minutes.
If you permit intervention of one political party, we'll have to have
Only
a.
one intervention is allowed.
No, no.
They have not yet started. even.
Not yet, Malad.
They are not hearing Mr. Gopal Shankar Narayan.
Malad, I 5 minutes, I place it.
We are no, if we permit one political
Only
party,
new facts, Malad, nothing else. Malad, other,
no facts, we are only.
Malad, on the law.
Let the states complete, the state of Telangana has yet not been heard.
Malad, after them, then I'll make my submissions.
We don't know, we.
5 minutes, Malad, I'll place it, Malad.
We have a sequence which we've been following, Manoj.
That's right.
So Reddy is supposed to be next. We are following.
Mr. Wilson, but then he's been shown as an intervener, so.
Mr. Reddy is next.
Lord, on
As per the
our
sequence.
side, we have requested many interveners not to come.
Yes.
Malad, I'm only placing, Malad, two discussions, Malad, constitutional issues, Malad.
But
Article
we have heard the state of Telangana extensively.
Malad, 175, Malad,
Tamil
how-
Nadu extensively.
Malad, Malad, but
Let
because of
let the state of Telangana address.
yes,
Let
Lord,
the
I'll
state-
wait, Lord. Lord, as per sequence, Lord, my name is there. Lord, we are.
We know, but then we are not
No
allowed,
reason, Lord, for this reference.
we are not allowed the intervention application.
Lord, we are the sole reason for this reference. Lord,
Maybe, but then state of the Tamil Nadu has opened the argument.
we thought, Lord, some
No, no.
important points, Lord. which-
One political party, then we'll get hundreds of political parties.
Lord, one intervention is already allowed, Lord. That's why Sir Gopal Sankaranarayan is appearing for them.
Who?
Sir Gopal Sankaranarayan.
Five interventions.
5 minutes, that's all, Lord. 5 minutes.
For the Gopal sir and
One for my-
five
five minutes.
interventions were allowed on the first
Allowed
day.
already.
We have all been waiting patiently. Somebody, because the opportunity has been lost, is now coming on an
No, no,
intervention.
sir,
That's
I'm
what is
also there,
happening.
sir, for the day one, sir.
No, no, but it's,
Since
you
8
are
days we
saying
are
that the
waiting
case
for-
arises because of state of Tamil Nadu. The arguments were opened by state of Tamil Nadu and we have heard extensively for more than a day.
First we'll complete states, let him start.
Let
Five
the state complete.
Lord, I'll leave it to your Lordship. Lord, I'll wait if your Lordship permits me.
We'll look, first let the states be argued.
Yes, no, I'll wait, Lord. I'll wait.
I have filed my submissions. After the submissions were filed, some part of this contentions have been covered by Mr. Datta. So I'll try to, my lord, skip over those parts. The lordships would have the index on, my lord, on page 1318. The short submissions I want to make, my lord, are on the 6 issues. My lord, first, on the aspect of advisory. I'm sorry, my lord.
Hey, where is yours?
My lord, volume 212.
Page 1318.
Yes, ma'am. Starts from 1317. But at 1318, my lord, I've just indicated the headings under which.
Yours starts at 1317.
That's correct, my lord.
Before that, it is probably Mr. Wilson's note, 1309. The same comparison.
Yes. Lord, 1318, I've just indicated the headings in which I wish to assist your lordships very quickly. My lord, at page 1320, my lord, is my submission that I wanted to make to your lordships on advisory jurisdiction. My lord, the first submission I wish to make is that the advisory jurisdiction is more expansive than a regular judicial review. My lord, because normally, my lord, when your lordships are undertaking judicial review exercise, my lord, then your lordships are constrained by the separation of powers. Your lordships may be little wary of stepping into, my lord, a legislative area or an executive area, because, my lord, those are separate organs. But in an advisory jurisdiction, what happens is your lordships are now invited by the president, asking your lordships to give legal advice on what the president and the governor should do ordinarily, which is done in the legislative or executive space. But one of the questions is, can a bill be commented upon before it becomes law? My lord, your lordships in special courts, my lord, matter has actually answered this, because contentions were raised by some people saying that if it is a bill, it is a property of the House, it cannot be touched upon by the Supreme Court until it becomes a law. My lord, your lordships, my lord, in this judgment of 1979, volume 1 SCC, page 380, I'm not reading this. Lord, the only page number, my lord, is 3661. Your lordships have answered that even a bill, before it becomes a law, while it may be in the legislative space, if the Honorable President has sought a reference under Article 143, my lord, then on aspects on the legality of the bill, since they are asked by the Honorable President, my lord, they can be commented by the Honorable Supreme Court. So, my lord, if my lords would kindly have page 1312.
Where is that judgment?
My lord, that judgment, my lord, is at page 3661,
Mr. Datar had cited it.
volume
Which-
5.9.
Which one?
My lord, this is special courts reference, my lord.
Chief Justice Chandrachud's passage.
Yes,
But I'll invite my lordship's attention because I just have a couple of points to make on this. Now at page 1320, my lord, in this first part, my lord, this para 1.1 to 1.4, 1.3 are the, my lord, points I just made for your lordship's consideration. Since it is at the invitation and indication of the Honorable President requesting this Honorable Court to explain as to what is expected of a governor or a president under Article 200 and 201, my lord, your lordships would now be advising, my lord, the President and my lord, through the President to the governor as what is to be done in terms of the expeditious matter in which they will have to conduct the matter. So normally in a judicial review, the two-judge bench in state of Tamil Nadu possibly was it was cautioning itself and it was saying that this time limit is imposed by us only to act as a lodestar for any judicial review action to be filed. But my lord, now the doors have been opened wider because, my lord, if your lordships looks at this in a sterile, non-confrontationist manner, your lordship said facts will not be looked into, pure constitutional principles, my lord, will guide your lordships when your lordships are answering this. So, my lord, if I have to now treat this, my lord, as a pure constitutional question that is placed before the Honorable Court, I see it coming from no less, my lord, than the highest constitutional functionary of the Honorable President. Maybe, my lord, because of state of Punjab, state of Tamil Nadu, state of, my lord, Telangana.
Telangana is not yet either.
That's correct, my lord. Now, there may have been a doubt that may have arisen in the minds of the Honorable President. The Honorable President now seeks guidance from your lordships as to what is meant by this as soon as possible in Article 200. The exclusion of, my lord, while the question is not framed in that manner, the exclusion of 6 weeks, replacing it with as soon as possible in Article 200, does it have any special portent? Should the governor be mindful of a time frame within which the governor needs to act? Should the Honorable President be mindful if the matter is referred to the Honorable President under Article 201 with regard to what is to be done? Now, my lord, your lordships, as I indicate, my lord, I use the word colloquially, the doors, my lord, are now opened by the Honorable President requesting your lordships to guide the Honorable President and the governors. So what may otherwise have been an inhibitive factor for your lordships to indicate a time frame, your lordships can easily specify if your lordships are able to find from the constitutional scheme, from the constitutional debates, that the intention throughout was that they would act with utmost expedition. If 6 weeks' time was removed in the draft article, in your lordship's understanding of the law and the constitution, if your lordships find, and my lord, this is your lordship's opinion, your lordships are not giving a directive. It is your lordship's opinion that your lordships will be specifying in the advisory jurisdiction. So if your lordship's opinion, collective opinion is going to be that the governor and the president are expected to act with great expedition, preferably within a period of 3 months, because 6 weeks was what was contemplated, it becomes only your lordship's opinion. But your lordship's opinion being sought may end up being something that they may be bound to follow in the ordinary course. Lord, so therefore, my lord, my respectful submission at the outset is, this is a much wider jurisdiction your lordships have. They are only asking for your lordship's opinion and advice on what your lordships feel are the, my lord, components and, my lord, the time-related specifications of Article 200 and Article, my lord, 201. My lord, this is my first submission. But if I may just show, my lord, at page 1, my lord, para 1.4, my lord, this very issue that when advisory jurisdiction is conferred on, my lord, the Supreme Court, my lord, Canadian Constitution continues to have it. Australia, my lord, though it's a part of Commonwealth, it has removed these provisions because they felt that this may possibly lead to the Supreme Court encroaching into this legislative or executive spheres. They wanted to keep, my lord, these three completely insular. So, my lord, while the other countries have moved away, US does not have this jurisdiction. My lord, the Indian constitution consciously chose that they would retain this jurisdiction, my lord, like the Canadian constitution continues to retain the jurisdiction. It is that retention of jurisdiction, my lord, that was made by the honorable, by the constitution that led to the honorable president now seeking a lordship's opinion. My lord, I have only indicated in para 1.6, my lord, that the Canadian constitution is the closest parallel. My lord, then I am indicating in para 1.7 that this reference may need to be seen, my lord, from a constructive perspective. Not, my lord, an assertive jurisdiction, my lord, that is sought to be exercised. It is not, my lord, confrontational as I see it. It is, my lord, the honorable president understanding that there is a constitutional power available to the honorable president to consult your lordships. My lord, they have approached your lordships for seeking consultation. My lord, your lordship's opinion would be any just and correct view that your lordships take of what the constitutional provisions can mean and must mean. My lord, then, my lord, if I may go to the second part of my submission. My lord, this is at page 1322. My lord, just to indicate, my lord, I'm starting with what is the original intent. My lord, now this about the original intent, there cannot be a confusion. The point I'm trying to make is, my lord, that the governor has no discretion. The governor has no options.
No options also.
No options also. All the options are available only for the Council of Ministers to aid and advise the governor. The governor is bound to follow. This is the original intent. I'll show to your lordships. Prior to the constitution, my lord, 1935 Act resulted, my lord, in 1937 Government of India Act being brought into force. Congress, my lord, won majority in 6 provinces. They had a reservation saying that if section, my lord, the old section 75 of the Government of India Act had a discretion available to the Governor General. My lord, they said we would not want to assume power, though we have majority, because we may not be able to run the governments. My lord, an assurance was given by the Viceroy, and this is, my lord, recorded in Sarkaria Commission report, saying that we will not resort to this power, discretionary power, we will allow you to function fully. So, my lord, prior to the constitution being made, your lordships notices this history in 1937. 1947, my lord, the moment Indian Independence Act came to be passed, the constitutional provision order of 1947, my lord, immediately made a change saying that in his discretion exercising anywhere, because that old act was continuing till the constitution was made, in the adoption order, my lord, it was specified that this would not be operative. So by the time the Constituent Assembly was sitting, there was no discretion, my lord, that was available in terms of the Government of India Act because of the adoption order saying that in this discretion will not operate. My lord, I'll just show your lordships that. So when the Constituent Assembly sat down, there was a draft article. My lord, when the draft article was placed before the Constituent Assembly, 2 things happened. My lord, the draft article came to be placed with the, my lord, drafting committee suggesting a recommendation that we must drop this word in his discretion, because that was preceded by, my lord, Shiva Rao's book. I placed it, my lord, I'll just show your lordships. These drafts were initially put out for the public, my lord, asking for views to be given. When views were given, my lord, when the the drafting committee received these comments, such of those comments it found were feasible and were correct, the drafting committee itself, though it proposed the draft constitution by then, it proposed the amendments that need to be carried out. So by the time the matters come before the Constituent Assembly, the recommendation of the drafting committee by then was, in this specific article, Article 175, we may have to delete the word in his discretion occurring, my lord, in the first proviso. So, my lord, that, my lord, the Constituent Assembly debates will clearly show to your lordships that throughout, my lord, in the Constituent Assembly debates, the view of all the members was very clear that the governor will not have discretion, the governor will not have options. All the 3 options are for the benefit, exclusive benefit of only Council of Ministers.
So he has to act on the aid and advice of the minister.
That's correct. But also what happened immediately after the constitution, because this is something where, if your lordships looks at the arc of history starting from 37, after the constitution, when the president, Honorable Rajendra Prasad ji as president was, had a doubt about the Hindu code. He sought the opinion of the Attorney General. He sought the opinion of Sir Alladi. But in Shamsher Singh's case, my lord, just Krishna Iyer refers, my lord, to these conversations to say that throughout it was very, very clear the Council of Ministers would be exercising each of the options. The governor would not have any option. But if I may just quickly show that, my lord, from my note at page 1322. My lord, in 2.1, I had mentioned about, my lord, section 75 under the 1935 Act. My lord, 2.2 just indicated for your lordships, my lord, that then Congress party won the majority. My lord, it assumed office only after it received an assurance. At my lord, footnote 2, your lordships will find this is specifically referred to, my lord, in the Sarkaria Commission report, which is also a part of your lordship's order. This history is noted. My lord, then please see, my lord, in para 2.3, Nabam Rabia notices the constitutional, the next stage. My lord, in Nabam Rabia, if I may read with your lordship's permission, my lord, in that extracted part, after independence, there was no intention to permit the governor to exercise any discretion or to take any decision in his individual judgment. This is clear from the India Provisional Constitution Order of 1947 issued in exercise of the powers conferred by section 9(1)(c) of the Indian Independence Act 1947. Para 3.2 of the India Provisional Constitution Order explicitly deletes the expression in his discretion, acting in his discretion and exercising his individual judgment wherever they occur in the Government of India Act 1935. Then para 3.1 and 3.2 are extracted. So, my lord, 1947, in the first opportunity, my lord, they said we will have this adoption order, remove this in this word in his discretion, because earlier it was dependent only on the Viceroy's assurance. But in law, my lord, that words remain. Now, the moment, my lord, we got independence, they wanted to do away with this discretion to the governor. My lord, then para 2.4, I mentioned, my lord, about the draft article which I have extracted at, my lord, para 2.5. Your lordship sees the proviso under para 2.5. Your lordships will see originally, my lord, this in his discretion was a part of the draft article. My lord, then para 2.6, prior to the introduction of the draft constitution in the assembly in October 1948, the draft was widely circulated to the members of the Constituent Assembly for comments. Some members of the Constituent Assembly had suggested that the words which would enable the governor to withhold assent or reserve it for consideration or give assent should be deleted from draft article 175. Notes to the Constitution Drafting Committee specifically mentions this as under. My lord, I've enclosed this B.N. Rao's volume, my lord, for your lordship's consideration. My lord, I'm just self-contained. I've extracted all the relevant parts in this note itself. My lord, article 175, this recommendation, my lord, came from Mr. K. Santanam, Anantaswamy Iyengar, T.T. Krishnamachari, and Srimati G. Durgabai. In Article 175, for the words declare either that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the President, the words assent to the bill be substituted. This was the original suggestion. My lord, the note is by the constitutional advisor, Mr. B.N. Rao. My lord, the note then says, under Article 175, my lord, which is 200 today, the power of the governor to declare, my lord, page 1324. Yes, top of the page, my lord. That note, my lord, is by the constitutional advisor, Mr. Rao.
I had read that, my lord.
Yes. Under Article 175, the power of the governor to declare that he assents to the bill or that he withholds assent therefrom or that he reserves the bill for the consideration of the President. My lords, find all three adumbrates are there, will be exercised by him on the advice of his ministers. Accordingly, there will be hardly any occasion to withhold assent from a bill which has been passed by the legislature. There is therefore no harm in retaining the provision with regard to the withholding of assent from a bill in this article. Now, please mark this. There may be cases where it might be necessary for the governor to exercise the power of withholding assent, even on the advice of the Council of Ministers. If after a bill is passed by the legislature, the ministers resign before the bill is assented to by the governor, the new ministry which would be formed might not want the bill to be enacted and might advise the governor to withhold assent from the bill. But if the provision relating to the withholding of assent is omitted from this article, it will not be possible for the governor to withhold it. Now, if I may pause. So this is, my lord, to aid the ministry requesting the governor to withhold and send it back. My lord, then if I may read further, there is thus a distinct advantage in retaining the provision relating to the withholding of assent in this article. The provision regarding reservation of a bill for the consideration of the president is also necessary in view of the provisions contained in clause 2 of article 231. My lord, this is 254(2). My lord, in fact, my lord, Mr. Datar had touched upon this. My note elaborates a little more. My lord, the Council of Ministers, when your lordships look at it as a law-making body, if it is making the law, your lordships will start with the good faith doctrine that the legislature, my lord, because your lordships are looking at it as a pure constitutional question. Now, in a pure constitutional space, divorced from facts, your lordships would not presume that a state legislature is not aware of the provisions of the constitution. My lord, when it is making a law, it would know which are the provisions which will require the assent of the president. It would know which are the provisions or which part of an enactment, not the entire enactment. My lord, it can only be sometime only one section, which may require the assent of the
That
president.
is already argued so many times.
My lord, if I may just then read further, my lord. 2.7. At a later part of the same note to the Constitution Drafting Committee, the constitutional advisor, Mr. B.N. Rao, remarked as follows. Accordingly, if the words in his discretion be omitted from the proviso to Article 175, the power of the governor to return the bill to the legislature under the proviso will be exercised by him on the advice of his ministers, and the remarks under Article 91, my lord, which is 111, ante will apply to this amendment. Then 2.8. In the Constituent Assembly debate as well, it was clearly noted that there would be no individual discretion available with the governor. The relevant portions of the debate have been extracted. But I have not extracted the entire portions. The learned solicitors has an extensive one. I thought relevant ones to this particular point, I'll place it here.
Tomorrow by 12, your side has to conclude.
I'll
do
take
that.
another 20 minutes.
We'll finish.
No, we're very faithful to time.
The interveners, my lord, I was just laughing at.
If they can fit it till 12 o'clock, we'll
This is normally you don't have rejoinders. We all give our views to your lordships and then your lordships take.
We are just assisting the.
There's no lists here that we have to respond to each other.
That's
Yo,
one.
how come state of Meghalaya is on this side?
Paul Shankaran thinks that there is no voice of dissent here.
Where the governor has been independent, he will act without aid and advice of the council of ministers.
On his own judgment, that's a sui generis.
No, but then you should have been on this side.
Not difficulty is the learned, despite our request, we are not getting placed from this side. My learned friend, my lord, is standing to assist the learned AG. But anyway, these are our internal issues, my lord, I can't flag it here. Meghalaya.